We continue our coverage of the Supreme Court's 6-3 decision providing Donald Trump with absolute presidential immunity that he requested and more. We are covering this from each and every angle. I want to bring in Mike Sachs, senior advisor to court accountability and a correspondent here on the MeidasTouch network for all things law, politics, and the United States Supreme Court. Mike, I want to talk more specifically about Justice Clarence Thomas's concurrence. We should talk a little bit, just at a high level, remind people what this decision was, even though we've done a number of other hot takes on it. But Justice Clarence Thomas's decision also gives a roadmap to Judge Aileen Cannon in the Mar-a-Lago document case. There's a lot of things going on as well in some of the other kind of concurring opinions, Amy Coney Barrett's concurrence, and how this all kind of fits together. But if you can remind people, I guess, just how horrible of a ruling this is, I think where you have a dissent like the one from Justice Sotomayor, or the one from Justice Ketanji Brown Jackson, which basically says that the majority has now created a monarch and has now made the United States presidency a king, and signs off with, for fear of our democracy, I respectfully dissent. But if you can maybe touch upon that, and let's get right into this Clarence Thomas dissent and the message that he's sending.
Yeah, not only, hi Ben, by the way, not only did the Supreme Court today by a 6-3 majority pretty much bless presidents to crime while in office if they have any colorable claim that it was part of their official duties, but also, writing separately, Justice Clarence Thomas said, and even if Jack Smith can somehow persuade the judges below and the jury below that these were not official acts that were in the indictment against Trump for trying to overturn the 2020 election, well, Jack Smith's appointment and his prosecution subsequently are both unconstitutional. Now, this was a question that was posed by Thomas at the oral arguments in April. It's something that Justice Brett Kavanaugh also seemed very sympathetic to, although he did not join Thomas's concurrence today. But the point of Thomas's concurrence today was to send a flare down to Judge Aileen Cannon in Florida, who is actually considering these arguments of whether Jack Smith's prosecution is unconstitutional because his appointment was also unconstitutional. This is a big deal, because this furthers the unitary executive theory that has been a hobby horse of the right-wing legal movement for a couple decades now, in a way to further consolidate and aggrandize power within the executive branch for issues of prosecutions of war, of personnel policy, of course, but not when the executive wants to regulate, because then the executive has no power under the Supreme Court's precedents this term as well. Also say that these are very, not just ideological, but partisan decisions in ways to aid their president of choice this coming election. This Supreme Court has chosen to delay at every single turn in this specific case. They could have dispatched it quite quickly back in December. If they wanted to rule this way, they could have said so. And then had it gotten back to Judge Chutkan at the DC District Court to parse the complaint from Jack Smith on what acts are official or unofficial, and if it's official, is it covered by immunity? If it's unofficial, then can it move forward? Judge Chutkan could have parsed that leading up to her March 4th trial start date, and then gotten the trial going, and then we could have a verdict by now on whether Trump is guilty of trying to overturn the 2020 election based on the allegations in Jack Smith's prosecution. Instead, the Supreme Court waited until the very last day of the term to hand down a decision that was already going to buy into Trump's delay tactic. So it's delay upon delay to ensure that this prosecution does not move forward before Election Day, so that the American public will not have a verdict in hand for who they're going to vote for in 2024 about someone who tried to overturn the election in 2020, whether he is by a jury of his peers guilty of that. So that's one thing. But now, even if it goes down to, it is going to go back down to Judge Chutkan, and even if it survives the prosecution survives the gamut of that, well, Judge Cannon down in Florida, now equipped with this concurrence from Justice Thomas, could then write an opinion herself saying, nope, guess what? Smith's unconstitutional. And that'll go right up to the 11th Circuit and then right up to the Supreme Court. And the Supreme Court will likely decide this again on whether the prosecution is constitutional. Now that, beside the point, you have the question of, well, there's so much going on here, Ben. But besides that is the question of when the verdict comes down, if there is going to be a verdict. Surely it'll be after Election Day. But will the prosecution decide to continue its prosecution so close to Election Day and following it? And then if Trump is elected, then what happens? Of course, he will move to shut down this prosecution. He will move to, and if the prosecution does complete and he's somehow convicted, he will move to pardon himself. And these are all the moving parts going on here with every fix in to ensure that this man does not face accountability for his alleged crimes of overturning the 2020 election, crimes against our democracy and the American public, let alone the congressional statutes. So that people going to the polls will be deprived of that one bit of information as they move forward to select our next president. This is an astonishing opinion, an astonishing decision, not just the majority, but also this one concurrence from Thomas, which gives a roadmap to further shield Trump from accountability.
I mean, as we pull back for a moment, just think about what it is that Mike just said. You have one of the right-wing justices as part of that 6-3 supermajority utilizing an opinion to send a roadmap to provide instructions to a judge who Donald Trump appointed after Donald Trump lost, in Judge Aileen Cannon, who was previously determined to have violated the law twice by the 11th Circuit Court of Appeals, who smacked her down when she previously tried to assert equitable jurisdiction in 2022. And now you have Justice Thomas, someone who we now know has been bribed, just blatantly bribed, over $4 million and probably more on lavish trips and vacation and yachts and living the high life, giving we the people, the middle finger. By the way, there's probably a correlation here that the person who was the briber, the person who gave him, we'll say this, it hasn't been officially determined to be a bribe, but the person who gave him lavish gifts and lots of money, Harlan Crow, had like fake Adolf Hitler paintings, or what's alleged to be fake Hitler paintings, and he would collect authoritarian statues and authoritarian portraits and pictures. This is the person who is giving Thomas these lavish gifts. And now Thomas giving the authoritarian roadmap also, not just in joining the 6-3, but giving Judge Aileen Cannon the roadmap there. Just think about that. In the United States of America, in 2024, and when you and I were in law school, yes, we knew about the Supreme Court's corruption. Yes, you were at the forefront of saying the abuses that they were going to have with the unitary executive. And, you know, we had at Georgetown Law School, we had the guy who created the Patriot Act. He was one of the professors, you know, in clinics. So we knew about it, but by the way, I lasted 2 days in that course before I dropped it. But did we think it would go here?
No, of course not. Of course not. No one expected a president that would try to overturn the Electoral College. Like, no one expected that. And we had a president who was elected because of the Electoral College and who was installed into the presidency because of the Supreme Court stopping a recount in Florida in Bush versus Gore. But we never had a Supreme Court saying that the president can crime while in office so long as he can make a colorable claim that a prosecution cannot rebut that these were official acts. Now, I want to direct you towards Sotomayor's dissent here because she sums this up. She says that when a president uses his official powers in any way under the majority's reasoning, he now will be insulated from criminal prosecution. Orders the Navy SEALs Team 6 to assassinate a political rival? Immune. Organizes a military coup to hold on to power? Immune. Takes a bribe in exchange for a pardon? Immune. Immune, immune, immune. That is a quote from Sotomayor's dissent on behalf of herself and Justices Elena Kagan and Ketanji Brown Jackson. This is the state of play we're in now. This was not at all expected by anyone. Now, let's go a step further. This court, the majority by Chief Justice Roberts, acknowledges as much that they've never had to decide a case like this because no fact has ever emerged to them. There's been no set of facts to create a criminal prosecution against the president for this kind of thing that came to them. So they could have said, well, this is about President Trump, this altogether unique figure in American politics that never before has a president tried this. And it's very unlikely in the future a president's going to try it. And if there is, maybe we can take on that in the future. But let's look at what President Trump did. Let's see what he tried to do while president to stay in office despite the will of the people. Let's just focus on that and make a decision based on that. But the Supreme Court said, well, never before have we had this issue. So we need to decide this beyond the completely egregious, once in a political lifetime, if not this country's lifetime, act of democratic criming. Anti-democratic criming against democracy. We're just going to look beyond that and look to some hypothetical future president that could do something worse. And in so doing, we will give that future president presumptive immunity from criminal prosecution. It makes no sense whatsoever. The only way to contextualize this is that these 6 justices in the majority, Justice Barrett gave a little bit of a qualification, but she joined in full in all the stuff that really matters. These 6 justices in the majority are trying to protect the electoral prospects of the Republican nominee who is on their political team for the 2024 election. I mean, there's just no other way to understand why they reached out and seized this case, delayed at every turn, and came out with a decision like this that is so obtuse, and breaks so much new ground to protect someone who has committed one of the worst and grievous assaults that one can imagine on a country run by people. To me, it just makes no sense. And then in doing so also to further their own right-wing agendas, to aggrandize the executive's power to pretty much have a completely, entirely, wholly politicized administration of justice that gets at one's political rivals, either criminally or not, with immunity. It boggles the mind. This is a massive decision. It was telegraphed all along the way. We knew what was coming, unfortunately, from the oral argument, but it makes it no less shocking when we see it written down here in print of 119 pages entirely of the opinion, the concurrences, and the dissents.
Mike, you're so right there. There's so many doctrines the Supreme Court utilizes to avoid having to reach kind of fundamental seismic shifts like this all at once. I mean, just the doctrine of kind of constitutional avoidance, where there's an off-ramp, the Supreme Court will almost always try to take it. I mean, here there were jurisdictional issues about whether this should have even been heard on an interlocutory basis at all, number one. But number two, this could have been far more narrowly, I think, decided on the issues, to your point, of the facts before it. And the Supreme Court didn't even have to hear it. I mean, right? The Supreme Court, even if it assumed it had jurisdiction, it could have just said, look, come back to us after there's fact finding that's done, after the jury reaches a decision, and we'll focus on what the jury does. We'll focus on the outcome of what the jury rules once we know the evidence that's in play. And here, to your point, you use the word seize. Like, they actually seized on this, did everything, to even give some sort of analogy feels a little bit, ridiculous given the severity of it. But it feels like, as you go back now, like one of these movies, whether it's like Who's Kaiser Sose or The Sixth Sense, and you go back and all of a sudden, all at once, all their moves flash before your eyes. Boom. And this is why they did it. And it's like, and then finally at the very end, they give you the middle finger. It all connects. And they're like, guess what? We're not a democracy anymore. See you later. Harlan Crow. We're going out. Time for our yachts. Time to party. We'll see you in South Beach. That's what they did.
And Ben, one thing you mentioned the word doctrine, right? We talk about doctrine when we learn about law in law school. We talk about doctrine when we read these opinions, and they talk about doctrine. There is no such thing as doctrine when it comes to the Constitution and the law, at least at this point in the court's history. It's all window dressing to effectuate what they want by sheer power of numbers. This isn't unique to this court necessarily in American history, but the anti-democratic nature of the doctrine that this court has been shaping, creating, modifying, what have you, is staggering and one that we have not seen in this court's history. And it's consistent with this current political moment in which this Supreme Court's right-wing majority's political allies are seeking to use and pull every anti-democratic lever of our Constitution to preserve their own power, to perpetuate their power, even when they do not have a majority of American public behind them. That's what this project is about. All of it. All of it, all of it. You can draw a straight line from the Roberts Court's inception to right now. It's all to preserve a political faction's power when they have lost a majority will from the public. It's a playbook that goes back, unfortunately, if we want to talk originalists, to the beginning of the country, when the Federalists, kicked out of office by the Jeffersonians, wanted to make sure they still had a stronghold so they could have a zombie branch chomping through whatever Jefferson wanted to do that was against what the first party wanted. And so Adams put Chief Justice Marshall on the court, and for about 30 years, the Federalists still had a zombified life, just even though they were revolted out of power in the early 1800s. We're seeing that now. This is the play. This is why McConnell packed the courts. Because when Republicans lose in the political branches, they will have a readout in the courts to make sure that their policies live forever and the Democrats cannot govern. And also to then help Republicans win office again. Now, this is not, I'm not saying this as a partisan thing, as a pro-Democrat thing or an anti-Republican thing. This is against one faction holding the political pendulum back hostage to prevent it from swinging per the people's will, because they do not want that. They want to keep it to themselves. And that is anti-democratic and un-American. And we're seeing that now coming into full focus at this Supreme Court. And we will see what dividends it pays in this 2024 election.
Well, I think the decisions, and I think people should at least know what's up, what's going on. You know, make the decisions as you will. But this is it's a rough ruling. It's a rough day for our country, and it's one of those days where kind of remember where you are at that moment where the decision was handed down, because I think it's forever changed the character of our country, and it's a sad thing to see. I'll give you the final word, Mike.
Yeah, you hear the term "justice delayed is justice denied." This case is an attempt to have justice delayed be democracy destroyed, but it's now on we the people to make sure that justice delayed does not become democracy destroyed, because this court will not save us. It won't. And anyone who still thinks that's the case for our democracy needs to understand those days are long over.
Well, hit subscribe. Let's get to 3 million. Let's make sure we get out this data. Let's make sure more people know and hear and learn about all of this. And Mike and I will keep providing updates. Mike from Corn Accountability, senior advisor there, and of course now a correspondent here on the MeidasTouch Network, all things law, politics, and the Supreme Court. All right, everybody, we'll be back with more breaking news. Hit subscribe, and let's get to 3 million.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.